Good morning, Your Honors. The matter before the court this morning is the case entitled Charlotte Barton versus Wharf Lane Housing LP and Burlington Housing Authority, case number 23 AP 177. Representing the appellant, Charlotte Barton, is attorney Nicholas Selden. Representing the appellees, Wharf Lane Housing LP and Burlington Housing Authority, is attorney Gary Michael Burt.
Okay, thank you, and good morning, counsel. We'll hear from counsel for the appellant first, of course. Please introduce yourself, identify your client, and then proceed.
Good morning. Thank you, Justice Reiber. My name is Nicholas Selden. I represent the appellant Charlotte Barton in connection with this appeal. Um, should
Thank
I
you.
should I just begin?
Yes, please go ahead.
Okay, thank you. So as an initial matter, I would just like to start by commenting on the Vermont Constitution, Article 12 in particular, which says that any issue proper for a jury, the parties have a right to that jury trial, and that jury trial right ought to be held sacred. Here, in this particular case, we were in the middle of trial. The appellees made a motion for a directed verdict at the close of plaintiff's case. And the judge, Judge Tor, had made some interesting comments, including the fact that she believed that the defense made some good points, which they did. That's why cases go to trial, because parties disagree with the facts. But Judge Tor also noted that the plaintiff had some good facts as well, and she thought there was enough evidence there to get to the jury. That decision was made. Therefore, Article 12 now kicks in. We get to the jury. There's a jury trial, there's a verdict, and that verdict is fair. There is no outcome in that verdict that is prejudicial or unreasonable. As a matter of fact, the jurors gave a very small verdict in addition to the economic damages. There are a lot of economic damages in this particular case, and they awarded the defense some comparative negligence as well. So I think here we have a jury that really thought about the facts of this case and came up with a verdict that they thought the evidence supported,
So,
and which,
Mr. Selden, let me interrupt you if I might,
please.
because we're short on time. The judge wrote a very well-written opinion on the Rule 50 motion after the jury came back. Very tightly written, in which she said there was no direct evidence of that would link the defendant to the accident that your client sustained. Um, what's your position on that?
So, Your Honor, I'm sorry, Justice Reiber, there is there is no one piece of evidence in this case. It's the totality of the evidence. This is a case with a lot of pieces of evidence that come together to form a totality of evidence that gave the jurors a good foundation, which Judge Tor had previously recognized in denying the defendant's first motion. There was a good basis for these jurors to return a verdict, and most importantly, our case grew stronger when the defense presented its defense because they called an expert witness who put in a lot of new facts which are quoted within our brief, and some charts that came in. But to answer your question, there is no one single fact. There are probably more than 20. I can sort of ramble them off, and but they are
So on a
contained.
on a on the basis of the law, with respect to the Rule 50 motion, what's your argument there? Given what it is that Judge Tor did and said in her opinion.
I'm sorry. Could you please clarify my argument with
Well,
regard to?
what's your argument on the law that to support your position that she was wrong? She says in the decision that there was no direct evidence. What's the legal argument that you're making that says that we should reverse her on that?
Well, so, Your Honor, I don't believe that Judge Tor had taken into consideration the legal obligation for her to essentially pick the evidence that was most favorable to the plaintiff and the inferences drawn therefrom. And that's what's so important here. And we went through it in our brief in great detail. I can get into the facts if you would like, but I think that what we have here is essentially direct evidence of wintertime weather conditions. We have direct evidence of the defendant's representative acknowledging that prior to Miss Barton's fall on the morning of March 22nd, 2017, she made the determination that ICE could blanket that parking lot, and she made the determination that no one needed to come in early to address it. And from that alone, jurors are able to infer negligence and decide that there was a breach of ordinary care. And the case law, as it stands right now, is that there has to be reasonable care under the circumstances, under the conditions. And that's
You mentioned inferences, and I know you cited a couple of cases in your reply brief with respect to this, and I can't remember the names of the cases off the top of my head, and because of the way we're handling briefing right now, everything's electronic. I don't have it in front of me. I'm sorry, but you may remember. Could you expand on that, please?
oh, um, I, which do you remember
Oh,
which
you
of
don't remember either? Okay, well, that's all right. Go ahead. That's
Uh,
okay.
so basically, we have a standard here that we're looking at, and it's not so much whether the Judge Torr is correct or incorrect. It's so much whether there is any evidence that reasonably supports the jury verdict, including
Okay.
the most beneficial inferences from the most beneficial evidence. And what the defense has done is they've tried to create this red herring argument that we had to have evidence, direct evidence of a forecast, and that's just not required. It's not required under the law. The defense is essentially arguing for new law to be created, and that's what Judge Torr did. She actually created new law. She said that as a matter of law, 3 hours is an insufficient amount of time, or 4 hours is an insufficient amount of time to remedy an icy parking lot once the ice has formed. That's
All
a
right.
new determination of law.
All right. I think your time has expired. Thank you very much.
Thank you.
We'll turn to Attorney Byrd. Please introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. My name is Gary Barton. My clients are the Wharf Lane Housing LP and the Burlington Housing Authority. As Your Honor pointed out, Judge Torr gave a very reasoned, well-articulated, and complete determination of why the verdict in this case could not stand. As she pointed out, there was no evidence of notice to the defendants of the icy condition. The icy condition did not start until 3 a.m. in the morning. There was no evidence the night before of ice falling or ice formulating on the parking lot. The evidence was that the plaintiff, 2.5 days prior to the accident, both in the morning and the afternoon, noticed the parking lot to be dry. The same was true on the next day. The parking lot was dry. At her deposition, sometime before the trial, she told me the parking lot was dry at 9 o'clock at night when she pulled into her parking space. And all 3 times said she saw no evidence nor need for treatment of that parking lot. Now, appellant's counsel has consistently said that Ms. McGonigal, the employee of the Housing Authority, knew that it was icy prior to the fall. In fact, though, what she did is she responded to a question saying, that morning I sent out people to do the work. He didn't clarify that. I had her clarify later on that it was about 7:30 in the morning after the plaintiff had fallen that she sent her staff out.
Mr. Byrd, why wouldn't this be a question for the jury, that the jury had proper instructions in front of them regarding the standard of care that needed to be applied, and what the burden of proof was regarding the standard of care that needed to be applied, and that is what was given to the jury to make a decision on? Why wouldn't we give deference to that decision?
Because as the court noted, Judge Torr noted, there was no evidence to establish either constructive or actual notice on the part of the defendants that would necessitate action taken on their behalf.
Here, I found, I'm going to interrupt you because I don't want you to run out of time, but I found the cases in the appellant's rebuttal brief. They cite this case called Burlington School District v. Kalkani, Frazier, Zakowski Architects. It's a 1980 case in 138 Vermont, in which it's written that in determining whether there's sufficient evidence to carry the matter to the jury, the court must focus on the tendency of the evidence, not its weight. It is not for the court to decide which of 2 and I'm reading it now, which of two or more conclusions that are supportable by the evidence is more correct? In short, plaintiff is entitled to the strongest inferences reasonably deducible from the most favorable evidence, and insofar as the evidence tends in any fashion to support plaintiff's claim, it is entitled to a jury determination of the issues. So what do you say about that?
Well, if there is evidence to support a claim, I wholeheartedly agree that the court cannot weigh the weight of the evidence. However, there was no evidence in this case. It was
Well, his
speculation.
position as your expert helped him out. What do you say on that?
All my expert said was that there was a mist that had fallen, which there was no disagreement about, and that the parking lot froze in all probability at 3 o'clock in the morning. What there was no evidence of was notice to my client that that was going to take place. There was no forecast for this event. Thus, my client didn't have actual notice, didn't have constructive notice. There was no evidence that that berm around the parking lot where the snow was piled actually melted and went onto the parking lot. In fact, there's a photograph, Exhibit M, which is before the court. In Exhibit M, you'll see that underneath her car, the parking lot is absolutely dry. Yet beside her car, there's some evidence of ice.
She had fallen there before?
Yes, but not anywhere near the time of this incident, a couple of years earlier. And so there was no evidence to support the inference that my client knew or should have known of the formation of ice in that parking lot. As Justice Torres said, there was no evidence of notice to my client. There was no notice until 6:30, later than 6:30, that there'd been freezing in the parking lot. The temperatures didn't drop below freezing until 3 a.m. and there was only 3.5 hours between that and her time of her fall. This case is closer, quite frankly, to the Bernasconi case than anything, because in Bernasconi, there was no evidence that the cemetery workers knew of or should have known of a hole into which the appellant stepped. And in that case, the Supreme Court upheld summary judgment, which is essentially the same standard as a motion for judgment under Rule 50. I see my time is up. I appreciate your.
Mr. Chief Justice, may I ask Mr. Burt?
Yeah, please do. Yeah.
Thank you, Chief Justice. So, Mr. Burt, did Judge Tor then usurp the role of the jury, however, when she made those particular findings that the icy conditions existed only for a few hours, wasn't reasonable for your clients to take precautionary action by sanding or salting? Should that have gone to the jury to infer from or make their inferences from the circumstantial evidence?
So she didn't usurp the function of the jury with regard to the time. We stipulated, there was a stipulation between the appellant and appellee that the freezing didn't take place until about 3 o'clock in the morning, a.m. As far as precautions go, you just don't do precautions, haphazardly. There has to be some evidence of the need to take those precautions, and there simply wasn't. That's why the absence of a forecast is so important, because that gives you constructive or perhaps even actual notice of a dangerous condition that's about to develop. I think we would all agree that in Vermont, if we were to take precautions just because the weather's unpredictable, then every road, every parking lot, and every driveway would have to be treated every night, regardless of what you know or don't know. And I don't think that's the law. That's why we're not guarantors of safety. We're only obligated to exercise reasonable care.
And you're really arguing direct evidence, not the circumstantial evidence, correct?
There was no circumstantial evidence to support the conclusions.
Okay. Yeah. All right. Thank you.
Thank you.
Okay. Does the appellant have any time?
Appellant has no time remaining.
All right.